Hi everybody, I'm attorney Kimberly Hanlon and I'm here to talk to you today about what is the difference between a will and a trust. I find that when I talk to people about estate planning that it's such a conceptual thing. You know, when you hear the word lamp, you have something that comes to mind because a lamp is something that exists in nature. I mean, you might not picture this lamp, you might have in your mind a different lamp, but you know what that means. When I talk to people about a will versus a trust, there's not anything out in the world that you can point to and say, okay, well that's what a will is, or that's what a trust is. And so it's harder for people to really wrap their minds around it. So the way that I have to explain it is sort of by analogy. That is to say, a trust is like a box. So let me explain that a little bit more. When you have a will, as far as your property is concerned, a will can really only do one thing. So let's pretend, set this aside for now, but let's pretend that this is everything you own. You have some cash, you have a car, you have some personal property, some stuff, you know, maybe it's jewelry, maybe it's fabulous, let's hope it is. Let's say you have a lake house. Let's say you have your regular house. And let's say you have a couple of pets. Some people think that their pets are like their kids, but it's not true as far as the law is concerned. Your pet is the same as a toaster. Okay, so what you can do with the will is you can say, okay, this is my stuff and this is who I want to give it to. I want to give this much to this person, and I want to give this much to this person, and that much to this person. So I'm going to give that, and this person's going to get my car, this person's going to get my stuff, and this person will get my pets, and we'll just give the house to this person and the lake house to this person. With a will, you can't say, I want this person to spend my money taking care of my pets. All you can do is say, here's my pets and here's some money, you do whatever you want, and so on. You also can't say, well, here's my lake home and here's some money and I want you to put some of that money into maintaining my lake home and making it available for, you know, my kids and my future generations to enjoy. All you can do is say, here's my stuff. And likewise, with a will, you don't necessarily get to say, I want you to get this money, but only if you're doing this thing that I want you to do, like you can have money to go to school for college or to start a business, but not to go to Vegas and have an awesome weekend. So a will is just like, there's my stuff, that's what you get. The other thing about a will is that it's all subject to the probate court, and so everything that you own, all of this, is a matter of public record. Every bill that you owe that gets paid is a matter of public record, and what you leave to everybody in your life, that's also a matter of public record. So some people aren't so keen on that. So that's how a will works. I don't have anything else to really tell you how a will works. That's like something that exists in the world. A trust, on the other hand, a trust is an entity in and of itself, like how a corporation is an entity in and of itself. A corporation gets created on a piece of paper, and that piece of paper gets filed with the state. And then all of a sudden it's like, okay, that's a corporation, and then it gets to operate in its entity form. A trust is the same thing. So other than the piece of paper that a trust is written on, there's nothing you can really point to. But a trust is like a box, and so I have a box to kind of demonstrate that. A trust is an entity that holds property for the benefit of somebody else. So you can put your money into a trust. You can put your house into a trust. You can put your lake house into a trust. You can, well, in a way you can put your pets into a trust, although I don't know that you want to start calling, your cat Rue, property of the so-and-so living trust. But, technically, you can put your cars, your other property, and everything sits in this trust. And it is for the benefit of somebody else. You, as the person who creates the trust, you're most likely going to be the first beneficiary. And then whoever you want to leave your property to after you're gone would be your next beneficiaries. The person who manages a trust, because it's an entity, somebody has to manage it, is the trustee. Often you are the first trustee. So often you are both the first trustee and the first beneficiary, and you're the person who makes the trust, which is called a grantor, and you're the one who puts your stuff into it. So really, in that way, a trust is it's like a box that you're putting all your stuff in. Because it's an entity, and it's created on a piece of paper, and it's like a contract, you can put rules around what's going to happen to the property in the trust. So you can say, I want all my money to stay in the trust, but I want until my kids get to be a certain age, I want them to be able to get some of the money to go to college. So here's some money that I will have available to pay out for college. But if my kids aren't going to college, then I'd rather keep it in there until they're a little bit older, or until they're ready to start a business, if that's something that's important to you. There's all sorts of rules that you can put around how the property gets distributed in your trust. You can also say, I want to give my pets to my sister because she loves animals. She'll take great care of it, but I don't want her to be burdened with it. So I want to give her some money to take care of the pets, but I only want her to use that money for that purpose. You can do that in a trust. So there's all sorts of things that you can do. Because a trust is its own legal entity, and because it already holds all of your assets, there's not anything that has to be transferred in, and it already has the transfer mechanisms built in. It has all the rules about when money transfers out and under what conditions, and there's somebody to manage it called the trustee. There's no reason that the court has to interfere with the trust. And so it's not subject to the very public probate procedure. So what you own is private, and what you owe, the bills that get paid, is private. The conditions you set up for distributing your property is private, and who gets what and how much is all private, which is really quite nice. So people ask, well, all right, that's like the basic trust principle, but why do we hear about all these different kinds of trusts? Like there's revocable trusts, and there's irrevocable trusts, and there's different trusts for all these different things. And that's true. There's a lot of different kinds of trusts. But speaking broadly, all trusts will fall into two categories, either revocable or irrevocable. So here's the difference. When you have a revocable trust, your property is all sitting in the box, but there's no lid on the box. And so you, as the person who created the trust, you can say, I'm going to reach into this box and I'm going to change my mind about this. I don't want this owned by my trust anymore. I want to own it myself, and that's going to be the end of that. And then you can sell it, you can do whatever you want with it, right? You could even say, you know what, I changed my mind. I thought I'd like this trust thing, but I'm not sure that it's working out for me, so I don't actually want to trust anymore. And you can get rid of your trust. So one of the rules about trust is that if you have the ability to reach in and take something out of your trust, then your creditors also have the ability to compel you to reach in and take something out of your trust. So if you are sued in a lawsuit and there's a judgment against you, your creditor can force you to take something out of your trust and give it to them or sell it to pay them off. If you were to file bankruptcy, whatever's in your trust is subject to your bankruptcy. That's how an irrevocable trust works. Now, there are certain times when people want to do an irrevocable trust. And the difference between a revocable trust and an irrevocable trust, I would say, is that the box has a lid on it. And because you put certain rules in place, like you don't have as much control, or you're limited to what you can do with the income or the principal, or the distributions of the trust. There's different rules for different types of trusts, but speaking broadly, an irrevocable trust is one that you can't reach into and take things out of. But because you can't reach into it, see, you just can't. I mean, there's a lid. Then that means that your creditors can't reach into it either. And Uncle Sam can't reach into it. I mean, and I'm speaking generally, I'm speaking broadly. There are, of course, some exceptions, like if you transfer things in on the eve of being sued, it can be considered a fraudulent transfer. There's exceptions for medical assistance. The state does want to get whatever they can get coming back if you end up using long-term care. But broadly speaking, this is how that works. Irrevocable trusts are great in that they can be set up for asset protection for you. It can be set up for asset protection for your beneficiaries, for your kids. Sometimes there's asset protection trusts that go on for generations that are called Dynasty Trusts. And a lot of the wealth in the U.S. is used in Dynasty Trusts to start or grow businesses and just keep people educated and self-sustained for generations into the future. So that is the basics on the difference between a will and a trust, and of course the difference between a revocable and irrevocable trust. If you have more questions about this, please give me a call. I'd love to be able to answer whatever questions you have about will and trust planning. Thanks.